SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. When people die without leaving a valid will, their families can be thrown into confusion, conflict, and upheaval. More than 76% of South Africans don't have a will, even though anyone over the age of 16 can write one without professional legal assistance. In cases where a will is not written up properly, it's up to the master's office and the courts to decide whether the will is valid.
It's actually very important for people to draft a valid will. I mean, we've got the whole lifetime to prepare our wills. We must make this as clear as possible so that you don't leave those behind you with a dispute that has to be dealt with in court. There's enough opportunity for all of us to be able to prepare a will properly.
Richard? Richard? Richard, sengibuyile. Richard. Richard! What have you done, Richard? What is it?
Emergency call center, how can we direct your call? Hello? Is anyone there? Hello? Is anyone there? Can you hear me?
The difference between intestate succession and the testate succession is that in terms of the testate, it's where a person dies leaving a will. Intestate is where a person dies without leaving a will.
If you die intestate, the fight definitely is always too much, because remember, many people can come as well, and it is very rare that someone can die leaving behind no relatives, maybe no children and no friends. And remember, if you die intestate, many people will definitely come, and they have got a reason to come forward and claim. Unlike when one leaves a will behind, it's very clear, it makes things very simple. You know how this estate should devolve the assets of the deceased. So it's always better when one leaves a will behind.
The estate of the deceased person must be reported to the Master of the High Court within 14 days of the death. The death must be reported by any person who possesses any document that is or intends to be the will of the deceased. The estate must be lodged by completing a death notice and reporting documents, which are available from any office of the Master of the High Court, any magistrate's office, or at www.justice.gov.za. For more information, contact Master of the High Court helpline 012-315-1207 or email chiefmaster@justice.gov.za.
People normally don't know what to do when the person dies. It is always important to go to the magistrate office when the person has died to go and find out. The Guardians Fund is the fund that has been created to administer the monies of the minors, of the people that cannot manage their own affairs, and the people that they are known as, or the people that the whereabouts are not known. Then to find out whether you've got the money, there's a government gazette that is publicized and advertised every September. It has the name of the beneficiaries.
Lindiwe went to the master's office to report the suicide note and discuss her options.
So washiya iwill yakhe kwi-safe kodwa waphinde wabhala inote yezinto ayifuna ukuzishintsha kuleyo will?
Yebo.
Ngayibona please. Lento ithanda ukuxaka.
Usho ukuthini?
Sengisebenze iminyaka ewu7 as a master of the high court. Ayikho neyodwa i-suicide note eyakhe yathathwa as amendment to a will.
Ngempela?
Kunjalo kodwa angisho ukuthi ungazama ukwenza i-application enkantolo to get it as an amendment, but I wouldn't get my hopes up.
But the note is so specific. Bengicabanga ukuthi if incwadi ibhalwe ngumuntu ngesandla sakhe, it would count for something.
Kuvama ubanjalo bengabe kuyi-signature, but for any will to be valid, the document needs to be witnessed by umuntu. Ngiyaxolisa kodwa angeke ngikwazi ukunika imvume to transfer lezi zinto azibhalile la.
Kodwa bengicabanga ukuthi unawo amandla ukapprove that kind of a note.
I can approve regular documents. Ngebhadi angeke ngikwazi kule.
Kodwa incwadi yachaza ukuthi befuna senzeni ngeproperty yakhe. Why would anyone ask someone to witness their own suicide note? Umbedo lo.
Ngiyazi it's frustrating, kodwa abantu abaningi abathembeki kulezi zinto. The amount of fraud eyenzekayo kulezi zinto is mind-blowing.
The note is real. Ibhalwe ngesandla sakhe. I will never fake anything like that.
Ngiyazi, futhi angikuphikisi nakancane kulokho. But these laws are there to protect the people. Ngebhadi, it doesn't apply to your unique case.
Well then, fanele ngithini manje?
Ngisuggesta ukuthi uthole ummeli who works on a contingency basis. Niqale ukusebenza ngokusheshsha.
What happened in that case is that the deceased left a suicidal note to his partner, living partner. They were not married, saying that the partner must inherit the house and the money in the bank. It was an amendment to the will because he had an original will in safe. So he knew that he didn't include the partner in that will. So he left just a suicidal note. That was not complying with the formalities of the will, and the master couldn't accept that as the amendment to the will.
Coming up, Lindiwe applies to court to have the note accepted as a valid amendment to the will. According to the Wills Act, the basic formalities required for the execution of a valid will are that the will is signed at the end by the testator in the presence of 2 or more competent witnesses present at the same time, who must sign the will in the presence of the testator and of each other. If the will is more than 1 page long, each page must be signed by the testator anywhere on the page.
The purpose of the requirements for formalities in terms of the Wills Act is twofold. The first is to ensure authenticity of a document that is referred to as a will. And the second is to avoid fraud. As we know, it's very easy to duplicate such documents.
It's important that whatever is contained in the will must be a clear expression of the intention of the person that is drafting the will. So the presence of the 2 witnesses needs to ensure that indeed what is contained in the will is the intention of the testator, that is the person that is drafting the will, and also to ensure that if the testator has since deceased, there can be no tampering of the will or variation of the will to suit some or one of the parties that are still left.
But however, the court does not blindly want that people should comply. It also considers as well the circumstances and surrounding circumstances, in fact, under which this will was drafted. Say one maybe is very sick or is unable now to take a pen and sign a will. Court will look as whether did he make a positive contribution in terms of dictating what must be done, and as well instructing somebody else that please take a pen now and append your signature on my instructions, and still that will be allowed.
When Menzi, the son of the deceased, heard about Lindiwe's application, he decided to oppose it, arguing that the note did not meet the required formalities for an amendment to a will.
My lord, this is an application for an order by this court to accept a document left by the deceased as a valid amendment to his will. The document in question is a suicide note dated on the day of the deceased's death.
Do I have this document?
Your lordship, the original document marked Annexure A is before the court.
Thank you, Ms. Watson. Mr. Dlom, is there any dispute as to the authenticity of this document?
No, my lord. The respondent admits that the handwriting is that of the deceased. The respondent's case is merely that the document is not a valid amendment to the will of the deceased.
Very well. Ms. Watson, please continue.
My lord, I submit that the contents of the note make it very clear that the deceased intended it as an amendment to his will. The applicant had been living with the deceased for the past 7 years and had become partially dependent on him. It's highly unlikely that the deceased would have taken his own life without considering the welfare of the applicant, and his means of doing this was through the suicide note. In it, he wrote, Lindiwe, the house is now yours. You will obviously sell it in order to meet all your needs. I also authorize Grand Plus Bank to give you immediate access to my savings account. There is 467,000 Rand, which shouldn't leave you struggling. My will is in the manila file in the safe. I leave everything else to Menzi. There is no ambiguity in these statements, my lord. And the note's contents give clear instructions as to what the applicant should do with the aforementioned assets.
Of course, you can make an addendum to a will. It is legally referred to as a codicil, and an amendment is an amendment. However, either the supplement or the addition and the amendment needs to follow the same process as the original document or the original will.
The suicide note is not generally regarded as a codicil or as an amendment to the will, but when one does a proper scrutiny of this suicide note, it's clear that the suicide note refers to the existing will, and it also sets out very clear instructions in terms of how the property of the deceased needs to be disposed of.
My lord, there are many elements in this suicide note that do not comply with the legal formalities of a will. It could not have been the intention of the testator for the note to be a formal amendment to the will, as the deceased didn't even sign the note. He merely wrote his nickname, which doesn't constitute a valid signature.
In this case, the fact that the testator wrote his nickname, it was quite clear that it's still him. The most important thing is the proof that the person that wrote that will, each and every page of that will, it's actually the testator that is the person that is disposing of his or her property.
In terms of Section 2.3, the court may condone that document which does not comply with the formalities. For example, it might not have a signature on it. But the test that the court will apply is whether that document unequivocally shows the intention of the testator for that second document to be his last will and testament.
Coming up, will Lindiwe convince the court that Richard did in fact intend the suicide note to change his will?
My lord, this document is a personal and emotional note, and it is highly unlikely that the deceased would have considered formalities such as leaving a signature, considering the dark space he must have been in when he wrote it. Although it is an unconventional method of amending a will, it's reasonable to infer that the deceased intended the suicide note to regulate the distribution of his estate. According to the Wills Act, a formal signature is not a legal requirement. Our law requires that a document changing an original will be written by the testator with a clear intention of amending the will, and I submit that that note did that.
My lord, any codicil to a will needs to be witnessed by 2 additional people in the presence of one another. This is a key formality with regards to writing wills. Although this note gives clear instructions on what to do, there is no one to testify what frame of mind the deceased was in. He could have been wrought with guilt and not thinking clearly.
I object, my lord, on the grounds of speculation. Although the deceased was in turmoil, he had the presence of mind to deal with practical and down-to-earth matters.
Sustained. Mr. Dlomo, please continue.
Regardless of the deceased's state of mind when writing this note, he already had a legal and a binding will in his safe, in which it was explicitly stated that all of his estate be left to the respondent. My lord, as you know, the law provides that the test in cases such as these is what the testator intended.
Strict formalities in respect of the wills cannot, in all instances, be followed for a number of reasons, and the courts are well alive to this effect, and then the court can therefore be in a position to condone a will that is not following the strict formalities as set out in the Act.
Thank you to both counsels for the benefit of your submissions. I would like to take a brief adjournment of 15 minutes, and then I will give my judgment.
Oh, sorry.
Lindy, I hope you know that you're wasting your time, sis.
Menzi, uyifundile incwadi futhi ayazi ukuthi bengeke ngishina lutho.
But he did.
Why are you being like this? Bengicabanga ukuthi singabangani.
Us. Friends, Lindy.
Yes. Menzi kudala sazana futhi mina bengicabanga ukuthi habe sinenhlanhla ngoba siyazwana. Why don't you want to listen to your father's wishes?
What? My father's wishes? Lindy, if you knew what my father's wishes were, he'd probably be still alive.
You know very well, Menzi, how hard I tried to get him out of his depression. So ungalokoti unsole ngokufa kwakhe.
You didn't try hard enough, Lindy.
Where is all of this coming from, Menzi, eh? Have you spoken to someone since your father died?
Hey, you're right, man. I never liked you from the start, Lindy. No matter how hard you tried, I saw right through you. All you wanted was Imali Kababa. And now, you think you're going to get it? Well, get this. I
really hope that's your grief talking. I can't even imagine ukuthi baba kangathini makhuluma kanje.
Hey, actually next baba wami mina. I've known my father a lot longer than you have.
Is this because he didn't leave you a note?
Don't be ridiculous.
Ebekthanda means he said as much in the note. It would break his heart if he knew that you doubted that.
It is possible for a person who otherwise would have benefited from a will to challenge a subsequent will, such as perhaps as contained in a suicide note, on the basis that perhaps the person was not in their full mental capacities at the time of changing the will. But then again, that person would have to put forward evidence in front of a court of law.
Each and every particular case will be decided on its own merits. So it was therefore reasonable for Menzi to approach the court and oppose the application because it was with the discretion of the court to accept or not to accept, but for himself not to act recklessly, he had to approach the court and protect the assets of his father.
It's common cause that the note left by the deceased didn't comply with the required formalities. That much has been made clear by the Master of the High Court. And it is for that very reason that we are all here today. However, I find many of the issues addressed here irrelevant to the intentions of the testator test. Considering the wording of the note and the surrounding circumstances, I feel that the deceased did intend the note to be an amendment to his will. He plainly addressed the fact that the original will he had in his safe was there and was to be adhered to, along with the additional aspects he addressed in his note. The note also gave implicit instructions on what was to be done to his estate once he died. The required formalities may not have been present, but I believe the deceased did intend the note to be a codicil. Therefore, the application is granted, and the master is hereby instructed to incorporate the contents of the suicide note as part of the valid will of the deceased.
As it pleases the court.
As it pleases the court.
All rise.
In this instance, it was a suicide note, but on this suicide note, as indicated earlier, there was a reference to an existing will. Quite clearly, therefore, the intention can be inferred that the deceased in this case wanted to tamper with the existing will. Beyond that, the testator makes very clear instructions for the disposal of the property. So taking in all those things in totality, the court was able to come into a comfortable conclusion that indeed the expression of the intention of the deceased can be clearly detected from the suicide note, and thus accordingly validated the suicide note as a codicil.
The Master of the High Court is responsible for the administration of deceased estates. The Guardian's Fund is also administered by the Master's office. It's a fund created to hold and administer funds that are paid to the Master on behalf of people such as minors, persons incapable of managing their own affairs, and missing or absent persons. If money is being held in the fund for you, you can apply to the Guardian's Fund for maintenance or allowance. If you are a minor, you must wait until you reach the age of 18 unless the will of the deceased provides otherwise. For more information, contact Master of the High Court Helpline 012-315-1207 or email chiefmaster@justice.gov.za. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.